Hi, welcome to week 3 of Knowledge November. Today I want to talk about the balancing exercise that any employer is going to have to go through if they're trying to determine what to do in a given case where there has been misuse of social media. I like to think about a weighing scales, and you've got two pans on your weighing scales, and the employer's having to balance out a number of different factors in those weighing scales pans to decide which side of things to come down on. Length of service is going to be an important thing to put in the pans of that weighing scales. Obviously, if somebody's got long service with you and perhaps a clean record, there's never been any problems with them previously, then that's going to militate towards perhaps not dismissing them and giving them some kind of warning. Whereas obviously if somebody's only been with you for a short period of time, or indeed you've had course to discuss with them previously something to do with social media, then that may well militate towards stronger action in this particular case. The seniority of the employee is obviously going to be relevant as well. If somebody is in a more senior position where maybe they have a role to play in terms of being the face of the organisation or being the person that everyone looks to for comment, obviously if they are caught making inappropriate comments, then that is going to put you in a much stronger position perhaps to do something about it compared to somebody who is not going to be known as your employee. It's interesting, one of the recent cases that I've picked up on where it was within the range of reasonable responses to dismiss was a Facebook case against an electronics company where the employee had on her Facebook profile put that she worked for the particular employer, and she'd made some inappropriate comments on Facebook about working there. Obviously, there was that link then made to that organisation, so you can just see how that makes a difference. The type of work that somebody's involved in is going to be relevant. So, for example, if you work with children, or if you're a charity, or lots of different types of organisations, there may be specific angles that come into play because of what it is that that organisation sets out to do. Obviously, if somebody then is saying something that doesn't fit with what that organisation believes in, or is marketing themselves to the world as, then that may be a relevant factor to consider. The attitude of the employee themselves is going to be important. If somebody has taken a post down, realised it was a foolish thing to do, and has sort of held their hands up and shown some responsibility for their actions, then obviously you're going to have a different reaction to that than perhaps somebody that can't see they've done anything wrong, or denies doing anything wrong, or refuses to see that what they think is their freedom of expression perhaps is something that you might have some concerns over. Any steps that they take in mitigation obviously may be something that you need to take into account in terms of reducing the penalty that is applicable to them. I wanted to just talk through the case of Game Retail, which is the first case that went to the EAT on this subject. And it's an interesting case because the chap involved worked as a loss adjuster, and he didn't have his employer on his Twitter profile or anything like that, but he'd been followed by a number of the stores that he worked with, 65 out of the 100 shops that he worked with, and obviously a number of the staff that worked there. And I can only describe his activities on Twitter as having a bit of a rant about most things. Dentists, caravanners, Newcastle football supporters, the elderly, the NHS, you name it. He seemed to have a bit of a rant about most things. People who drove slowly, you name it. Anyway, some of the comments that he made were racial. Some of the comments that he made were negative towards disabled people. An employee actually raised this with the employer and criticised his activities, so that's how it came to the employer's attention. There was also included on some of his posts the use of the C word, which I think probably is one of the factors that took this case into a different category. And initially, the first instance judge said that whilst customers or employees might find this offensive, there wasn't any public link, so the employer couldn't fairly dismiss the individual. That was appealed, and at the appeal stage, they pointed out that actually staff had complained about it because that's how it had come to the employer's attention, and that link had been made. So it was seen as a reasonable thing to do to have dismissed. So if you are going through this exercise of weighing up what you do in a given situation, I think a couple of 3 key things you need to be thinking about. Have you put the employee on notice that the kind of thing that they've been doing is problematic, usually in a policy, maybe in their contract of employment? Have we communicated that to people, and have we applied it consistently? It's no use if we don't take action and people can point to other cases where we've done nothing. Have we conducted a fair investigation? You're always going to get cases where somebody says, it wasn't me, it was the dog. It was my sister playing around with my phone or whatever it is. We need to have investigated that as much as we can to see whether there is a chance that could be the case. If it's not, then you may well be reasonable to come to the conclusion that that person is telling you lies, and that you decide against them, but you need to have at least addressed your mind to the issue rather than ignoring it. If anyone's got any questions, please do email me, adenton@refreshinglawlimited.co.uk. Thank you very much.